right? Yeah. Okay. I want to mess that up. Good afternoon. I guess we'll go ahead and get started. Thank you for coming this afternoon. Muters, people on Zoom, you are muted. Please stay muted. I appreciate that. If you have questions at the end after the presentation, if you put it in the chat, I'll monitor the chat and we can ask the speaker. If you're in the room and you have a cell phone, I'd appreciate it if you could silence it or turn it down so it won't be interrupted. And Danae is going to introduce our speaker for today. That one's on.
This one's on? Okay. Thank you all for coming. I'm pleased to announce, well, before I announce our speaker, I just want to say that you should have gotten, hopefully via email, a schedule. However, if you haven't, we have a couple paper copies, but we already have a change to the schedule. So next week, Amanda Phelan will be here to talk about tariffs and the economy. And the following week, Professor Lars Noah from the College of Law will be here to talk about vaccine mandates and public health policy. So it was going to be Gary Lawson who was going to talk about the Supreme Court, but that's been, I think, bumped to the 8th, assuming that he can make it on the 8th. So with that, I want to introduce today's speaker, who's Juan Caballero. He is a colleague of mine at the College of Law. He has his JD from NYU and his BA from Yale. He worked in, let me see, while he was at NYU, it was really interesting. He taught in the, that's right, he taught in the lawyering course at NYU. And prior to that, he was a staff attorney with the ACLU. And he teaches in our immigration law clinic, which is an experiential opportunity for students to come and learn about how to do immigration law courses. They actually represent clients and under the directorship of Juan. So he's going to tell us everything about how immigration works because I don't understand it. It's so complicated.
I was told I only had about an hour. I don't know if I can do a whole primer on how immigration works, but we'll focus on a few interesting topics. Thank you, Danae. Again, my name is Juan Caballero, the director of the Immigration Law Clinic, and I'm here to talk about some recent developments that have been taking place in our immigration laws and practices, right? There have been several high-profile stories, if you've been paying attention, over the last 6 months or so in this space. It's rapidly developing. We've seen stories of non-citizens being deported to CICOT, a high security prison in El Salvador, where we have contracted with President Nayib Bukele to basically detain or extradite these non-citizens in these confinement conditions. We've seen high-profile stories of masked ICE enforcement agents arresting people in various what used to be sensitive locations such as courthouses, hospitals, the like. We've seen stories about Alligator Alcatraz here in the state of Florida, where we have diverted emergency funding to basically repurpose this formerly abandoned airstrip to serve as a makeshift detention space, right? All of these are front page breaking news. I'm not going to focus on them for my conversation. I want to instead focus on something that is, I think, just as important and not really getting the front page treatment in our news, right? I want to focus on a battle that's going on between the states and the federal government over who has the authority and the ability to regulate our immigration laws. Here we have a picture of Governor DeSantis in 2023 signing SB, I believe, 1718, which is one of the statutes that we're going to be talking about today. I love this picture largely because the child standing next to DeSantis just has no idea what's going on. He's just clearly been told to applaud, and he's applauding, which is just such an excellent use of children as props. But what we're going to be talking about is really a series of developments and statutes that the state of Florida has adopted in the last 3 years or so, right? Starting most recently, we had in this previous cycle, SB 4C, SM 6C, SB 2C, which are a series of different statutes that touch on everything from education to law enforcement, to healthcare within the state. But they're the most recent iterations of a sort of longer stream of efforts to really sort of grow Florida's presence in the immigration sphere, right? Prior to this, we had a few high-profile major acts of legislation adopted by Tallahassee, which included SB 1808 in 2022 and SB 1718 in 2023. And we're going to talk about these in a second. But before we do that, I think we need to do some housekeeping, right? Just so that we can lay the groundwork and have a shared foundation. But what are the principles that shape our current immigration legal system, right? And here's where I'm going to turn it to you all, the audience, right? We're starting at the beginning, our Constitution, our founding document of this country, because if we're trying to start from first principles when outlining our immigration laws and immigration authorities, we should probably try to ground it in our founding document, right? And so I want to ask you all, the audience, what is your understanding of where the power to regulate immigration comes from in the Constitution? Anyone have any ideas? So because I was told because of the Zoomers, I need to repeat it. So maybe one by one. I heard one individual say Congress. Where in the Constitution does it give Congress the authority to regulate our immigration laws? Do you have a specific citation? So Article 2 would be Congress, yeah. But okay, maybe nothing more specific. So maybe somewhere in Congress. I heard another gentleman. What was your suggestion? The federal government. Okay. So any ideas on specific provisions that might be authorizing the federal government to work in this space? No? No? Necessary and proper clause? Okay, so we have the necessary and proper clause that's lingering out there that generally empowers Congress and the federal government to do an undisclosed, unknown amount of things. Is that where our immigration power comes from, though? That entrusts Congress with the ability to do it? Just somewhere floating out there in the necessary and proper clause? Oh, yes. So then, are you suggesting that our states should be regulating our immigration laws? Fair enough, fair enough. So if we can't find any specific provisions in the Constitution that delegate this authority to Congress or the federal government, does this fall under the specific category of powers that we delegate instead to the states? That's maybe one suggestion, even if that doesn't lead to the desired outcomes that we want. All right, one more, and then I'm going to reveal the honest truth. Yes, sir. Article 1, Section 8 says what? Naturalization, right? We do have a specific provision that deals with naturalization. Can anyone tell me what naturalization means? Naturalization is the process by which non-citizens become and acquire US citizenship. Okay, fair enough. That is in our Constitution. Does that give Congress the power to regulate our borders, create a visa system, create a system for excluding people, deporting people? No, but that is there, right? There's also the power to engage in treaty making, right, which we entrust to the federal government. There's also the war powers clause that we also give to the federal government. And those, plus the necessary and proper clause, is what the Supreme Court in 1892 determined created this presumption that the federal government, not the states, the federal government has the exclusive and presumptive domain of regulating our immigration laws, right? So it's a little bit of a wonky sort of system that came out of relatively nebulous constitutional grounding, right? We have a naturalization statute or a naturalization clause, we have war powers, we have treaties, and with the necessary and proper clause, we're tying all of these together to come to the conclusion that this gives Congress, not the states, the ability to regulate in this space. And not only the ability to regulate in this space, the presumptive authority to be the exclusive regulator in this space, right? That has been the paradigm that we have been operating in for about 150 years. Now, before we keep going with our story coming back to Florida, I'm going to introduce a few other side stories that help inform this discussion. And we're going to be going back about 50 years. We're not going to go all the way back to 1892. But instead, we're going to go back to 1975, and we have a few specific case studies that are going to help us understand how the courts have interpreted and reified this standard, this presumption that the federal government is the exclusive authority in our immigration space. And we're going to start by actually going to Texas. Texas in 1975 passed the Texas Education Code 21031, sorry, don't have my glasses on, which amongst other things prohibited the use of state funds for any public school that or for any unauthorized immigrants in public schools in Texas, right? At the time, it was billed as a measure to basically preserve budgets, but it was exclusively targeted at non-citizens, specifically what we would call today undocumented immigrants in the public schools in Texas. It gave rise to what would be the case Plyler v. Doe, which made its way all the way up to the Supreme Court, where the Supreme Court ruled that under the 14th Amendment, these students had a due process right to their education, right? And not only did they have a due process right, that basically the state's actions was unlawful discrimination against those students, right? At issue in this case wasn't really any sort of debate around who had the proper authority to regulate this. However, we see the seeds of what would later come into greater fruition in the subsequent engagements between the state governments and the federal government. Because not too long after Plyler v. Doe, which reinforced the rights of these undocumented students to attend public schools in Texas, we get California Proposition 187. Anyone remember Proposition 187? It was a pretty big deal when it came out. It was California, which at the time was dealing with a huge influx of immigrants, attempt to try to regulate and limit access to various state resources and state benefits for undocumented populations within the confines of the state, right? Amongst the different provisions of Proposition 187 was, like Texas Code 21031, a provision that prohibited the use of state funds for any schools that enrolled undocumented students. There were also some provisions that empowered the state police to investigate and detain individuals that they suspected to be violating our immigration statutes, right, who are present in the United States without authorization. So here, fast 20 years after Plyler v. Doe, we see that there's already starting to be a conflation between this public education rights and also immigration enforcement that was being demanded at the states, right? They were dissatisfied with immigration enforcement as it was being run by our federal government. And now the states were trying to take it upon themselves to try to enact regulations into this space, right? California Proposition 187 didn't go very far. It was actually enjoined relatively quickly, and the lawsuits ultimately struck it down as unconstitutional. It was not appealed to the Supreme Court, but because of that litigation, Proposition 187 effectively never went into effect. After California Proposition 187, we have what was up until recently a fairly seminal case in this space. And that case came out of Arizona SB 1070. This was also another big deal in the late aughts, early 2010s. Does anyone remember SB 1070? No? You might know it, or you might have heard it as the Show Me Your Papers law, right? Because amongst, it did several things, right? And it had 4 key provisions. And let me look those up just to make sure I don't get them wrong. California, or Arizona SB 1070 did 1, it created a state level crime for being unlawfully present in the United States. Remember that because it's gonna come back. 2, it created a state level crime for working without authorization in the United States. If you are a non-citizen, you cannot automatically work in the United States. You need to establish that you fall into a category and actually apply for work authorization in order to be able to work legally and lawfully in the United States as a non-citizen. 3, it required state and local law enforcement to verify the citizenship of anyone that they otherwise interacted with in the normal course of their business, right? So if you are at a traffic stop, now that Arizona law enforcement officer is tasked with the responsibility of asking about your citizenship status, even if it has no bearing on whatever driving offense is at issue. And then finally, it authorized the warrantless arrest of any non-citizen believed to be removable from the United States. So it was deputizing local law enforcement to basically enforce our immigration laws, right? Once again, an example of a state that was dissatisfied with how the federal government is running our immigration system and is trying to take it upon itself to challenge it, right? Like the previous Texas one in Plyler v. Doe, this state statute actually also led to litigation that made its way all the way up to the Supreme Court. And they weren't shy about what their intention was, the Arizona legislature, in passing this, right? The legislature declared that the intent of this act is to make attrition through enforcement the public policy of all state and local government agencies in Arizona, right? This was built into the preamble of the act, of the statute. They were very clear. We, as Arizonans, want to take over the duties of enforcing immigration laws, despite being a state. And that led to Arizona versus the United States. Once again, it made its way up to the Supreme Court. And in 2012, the Supreme Court considered the statute and ultimately struck down 3 of those 4 provisions, right? So they struck down the provision that related to the state level crime provision, right? You as Arizona cannot criminalize unlawful presence. They struck down the provision dealing with unauthorized work. You as Arizona are not in the position to criminalize unauthorized labor by non-citizens. And they struck down the provision that authorized the warrantless arrest of individuals who are believed to be in the United States without authorization. So provisions 1, 2, and 4 were struck down. Provision 3, notably, was not. Anyone remember what provision 3 was? I'm sorry. What about citizenship? They could ask about citizenship, right? So again, in the normal course of sort of police functions, that they could ask or investigate your immigration status. That was the only provision of Arizona SB 1070 that was upheld, right? And that was believed to be sort of it, or at least for a few years, right? The Supreme Court had ruled relatively conclusively that this authority to regulate immigration space belongs exclusively to the federal government, right? States are more or less told to stay out of it. But we're all here today. I've already probably hinted at, that's not the case, right? That was not the end of the story. States have increasingly gotten very upset about this. This issue has become heavily politicized. It's already been politicized for several decades now, but the debate continues, right? And the most recent iteration is what we see states like Florida, Texas, and a few other states engaging in, which is passing various types of legislation to try to either probe at the edges of this authority to see how far states can encroach into this federally regulated power or category, or to challenge it outright, to say that we don't agree with federal preemption as a doctrine in the space of immigration, and we think that states should have a role in enforcing our immigration laws, right? And here's where we're gonna turn to Florida. And specifically, we're gonna focus on 3 of those most recent sets of legislation, which I think are probably the most important or have the biggest impact on how immigration in the state of Florida works. The first is SB 1808, right, passed in 2022, which had a few different provisions, right? First off, it required all correctional facilities and state courts to report immigration status in their crime statistics, right? Just a transparency measure that requires this reporting. They're relatedly asking about immigration status. It required all sheriff's offices to participate in 287G programs. 287G is a reference to a statute, specifically a provision of the INA, the Immigration Nationality Act, Section 287, subsection G, which creates a deputization program by which participating officers, law enforcement officers, can be deputized to enforce our immigration laws. Now, under SB 1808, all sheriff's offices are required to participate in this program and at least have one officer on staff who's deputized to enforce our immigration statutes, right? In addition to that, it also prohibited state contracts with common carriers who willfully provide any service in the furtherance of transporting persons to Florida, knowing that they were undocumented, or as the statute describes them, unauthorized aliens, right? It has a specific carve out if you're transporting people into the state for the purposes of detention. But other than that, it just creates this generalized prohibition on transporting people as for common carriers into the state who are undocumented. The following year, we got SB 1718, and this is perhaps the biggest single statute that Florida has passed to date that sort of operates in this space. It had several different provisions touching on a number of different areas within the state of Florida, right? It prohibited the funding of community IDs. These are IDs often from nonprofit entities and organizations that served as a type of identification, right? Photographic identification that might help undocumented individuals, unhoused individuals, access various localized services, benefits, whatever, right? If you are a part of this marginalized population that might have difficulty securing a traditional form of identification, this was an alternative that might work in specific select circumstances, right? SB 1718 prohibited the use of any state funds for any of those projects. It required hospitals to gather information about individuals, patients, immigration status. So now if you go to your hospital, you might notice that there's a question often during the intake process where they ask you about your immigration status. That information is to be collected and reported at the macro level. The law does not allow for any violations of HIPAA, fortunately, but it does require the collection of this data, which has a chilling effect for a number of non-citizens who might be otherwise seeking medical treatment, right? It imposes financial penalties for employing unauthorized immigrants, right? It increased the number of employers who were subject to the E-Verify requirements. E-Verify is a program that allows employers to input information about their employees and check whether or not they're authorized to work. And relatedly, it requires E-Verify, sorry. It prohibited people from using certain out-of-state driver's licenses, and this was specifically a way of targeting any of those states that had more generous driver's license policies that allowed undocumented populations to get those driver's licenses. Now, in many of those cases, those driver's licenses weren't sufficient for this population if they were entering Florida, right? Now, you're effectively driving without a license because the state of Florida does not recognize some of those licenses. And then finally, and most egregiously, in my opinion, it also amended the human smuggling definition to include anyone who transports into the state of Florida someone that they know or reasonably should have known was undocumented, right? Now you can imagine who that might affect, right? Here in the state of Florida, we have a number of mixed status families, undocumented families, right? If at any point you are transporting your sibling, your parent, your child into the state of Florida, knowing that they're out of status, you are violating human smuggling. Certain nonprofits also help people go to embassies, consulate appointments, right? Some of those are cross state lines, right? If you're driving someone to the Mexican embassy in Atlanta and you know that that person is out of status or reasonably should have known that they're out of status, you might be violating our human smuggling statute under the state of Florida, right? Fortunately, this was challenged, and in Farm Workers Association of Florida versus Florida, it was enjoined. What I mean by enjoining is that there's a court order saying that you cannot enforce this provision of the statute. That litigation only concerned this provision. This is an injunction that came into effect at the beginning of the litigation. The litigation is still ongoing, but for now, the state of Florida cannot enforce this human smuggling definition that they adopted in SB 1718, right? At least during the pendency of the litigation. And then finally, and most recently, we got SB 4C, right? And this one was interesting, and it might sound familiar. What it did was it created two new state-level crimes. The first being illegal entry by an adult unauthorized immigrant. And the second is illegal re-entry by an adult unauthorized immigrant. If you've been paying attention, this might sound familiar because some of those previous statutes that we saw had provisions that looked remarkably similar to this, where states were trying to directly get into our immigration enforcement game, right? And those previous provisions were struck down. In addition to that, it also basically escalates the penalties imposed on immigrants committing certain crimes. And in the case of any type of capital felony, it requires the death penalty for any unauthorized alien, right? Like the previous statute, that one was also subject to litigation. In this case, Uthmeyer versus Florida Immigrant Coalition, which actually has made its way up to the Supreme Court on one specific issue, whether or not the state of Florida can begin enforcing this. Like in the previous case with the Florida Farm Workers Association, there was a preliminary injunction against the enforcement of SB4C that went into effect early in the litigation. That injunction has been subject to several appeals, and it's made its way all the way up to the Supreme Court, where at the beginning of July, the Supreme Court actually upheld the preliminary injunction, right? Now, as the name suggests, preliminary comes at the beginning of the litigation. The litigation is still ongoing, unfortunately, but during the pendency of the litigation, they cannot enforce SB4C. Now, just so that everyone can see what we're talking about, here's the opinion from the Supreme Court on it. Very detailed, right? That's all we got. An unsigned opinion of that basically the stay that would affect so many families would remain in place, right? At least, once again, during the pendency of the litigation. So all of this was to sort of hopefully cue up a conversation about how we should be structuring our immigration statutes, because as you hopefully saw, it's subject to several, it's been the subject of debates going back for several decades, right? This, while it's a settled issue within our jurisprudence, various practitioners, various politicians are dissatisfied with the current paradigm that entrusts our federal government and only our federal government with policing our immigration laws. When I've given this presentation previously, I was actually asked by an administrative law professor as to, well, fair enough, we recognize that these are challenges to the system, but do we want to maintain that system at all, right? As we see, it's already sort of built on a shaky foundation of we're pulling together various strands. We're pulling together naturalization provision. We're pulling together provision about the war powers of the federal government. We're pulling together provision based on the ability to make treaties with other states. And then we're tying it together with a necessary and proper clause and saying, that's what gives our federal government the ability to enforce our immigration statutes, not just the ability, but the exclusive ability to enforce immigration statutes, right? And whether or not that should be the law of the land, it is. But if we are trying to engage in more substantive discussion about how we should be structuring this, right? Maybe we should go back to first principles. Maybe we should ask it. Maybe we should reconsider it. I don't know that I personally am of that school of thought, because I do think that this is an area that certainly benefits from a uniform system where we have the ability to create, hopefully, clarity through our administrative process, through our court systems, a process that hopefully tries to create basic expectations across the nation rather than creating a patchwork of different options at the state level. But as we can see, this is open to debate, and it's obviously spurring quite an active discussion. With that, I will pause and see if we can open up for questions.
That was very clear. Thank you so much. Could you talk a bit about particularly how the Florida laws were developed? It seemed that DeSantis was on a roll in up to 2024 when he stopped his presidential campaign, more or less. But still there was 2025 law that seemed to have continued in the same vein. But I was under the impression that the legislature was trying to assert a certain amount of independence from him in 2025.
So I'm not a political scholar, so I'm not going to hold myself out as being the definitive source in that, but you're absolutely right, where obviously for some of these earlier pieces of legislation, DeSantis was certainly one of the principal driving forces behind their enactment, right? When it came to SB4C, the more recent enactment, right, that's where we saw this very public, very open sort of break between the legislature and Governor DeSantis in the adoption of that statute, right? At that point, he sort of lost control of the narrative, at least publicly. I can't speak to what's been going on behind the scenes or anything like that. And they sort of passed it despite his initial reluctance, right? Eventually, they got him on board, he signed it, it went into effect, right? But it does seem like there has been maybe some splintering of the coalition that's pushing for this type of very robust vision for state action in this space, right? Unfortunately, I don't know what the future portends for that sort of coalition that's pushing for a very robust role for the states. But that was maybe a sign of cracks that are developing. Absolutely.
Wonderful presentation. Thank you. One of my questions, and then I have a comment. Congress has failed. We keep on hearing Congress has failed for the last 30 years trying to do something. And we see it happening right now. Every time we get close to an immigration bill, there's something comes up, be it the Dreamers or be it the wall. There's always some reason not to do it. And this has been going on for a long, long time. And it's so interesting that the earliest states that you showed, California, Arizona, which were so restrictive in the 1990 and early 2000s, have now gone exactly the other way. And you know, California and the sanctuary state, sanctuary city, I'm not sure about Arizona, but I was thinking that maybe with what happened with Roe v. Wade being overturned, okay, maybe it's time to give it to the states. Because if the people in California want to have lots of immigration, and if they feel it's good for them, let them do it. Okay, but if the people in Florida or other states don't feel comfortable having lots of undocumented immigrants come in, then you know it's the same thing with abortion. Basically, what's happening now? It's states. The states are deciding what the rules are, not the federal government. And so that's my comment on it. And I'd like to know your thoughts on that.
Sure. I mean, starting off, I don't know if the repeal of Roe v. Wade has been necessarily a good paradigm of something we want to follow. First off, right, because it's been an incredibly messy system for trying to figure out, well, now what do we do? What is permissible and what's not? And of course, that's always going to be the case anytime we overturn precedent, right? There's going to be a period of trying to figure out where's the new lines that we're drawing, absolutely. But I don't know that the overturning of Roe v. Wade has been particularly seamless, right? Or at least without its struggles. There's been a huge amount of debate, huge amount of fracturing that's been taking place. And into the sort of the vacuum of the federal government, there's also states that are trying to enact statutes that might go beyond what they have the authority to do, even in this post-Roe landscape, right? By trying to police what happens in other states, right? To prohibit their citizens from traveling to other states. And I think that's also another difficulty that would make such a system potentially practically very difficult to enforce, right? What we've seen, and what I didn't touch on in this presentation, is the debate around birthright citizenship, right? President Trump, as one of his first executive orders, basically repealed birthright citizenship. He thinks he can do that through executive order, okay? That has been subject to litigation. It's made its way up to the Supreme Court, where the Supreme Court decided a specific issue. It did not decide the question of whether or not he was correct on birthright citizenship, but what it did do was it stripped district courts and appellate courts of the ability to enact these nationwide injunctions, right? This has been a tool that has been increasingly controversial, right? And basically the Supreme Court stepped in and said that we are no longer allowing these lower courts to affect policy at the national level, right? But part of that debate over birthright citizenship is, what does it mean to be born in one state that allows X and travel to another state that allows Y, right? It would be very difficult, if not unworkable, to say, I'm a citizen in Pennsylvania, but the second I step foot in New Jersey, now I'm what, right? And I think that if we have a system where California, Florida, Texas are all doing their own things, it would become very difficult because then we would need every state to effectively have border patrol policing their borders, right? What about the free movement of populations, right? What about our rights as citizens to be able to move around freely? And I think that there would be a lot of sort of very practical limitations. Could we work out a system? Maybe, but I think that that would make it pretty difficult to actually implement anything like what you're describing.
Juan, we have a question from online, if you could read that.
So the question is, was the Uthmeyer case 2015, which was stayed, part of what's known as the shadow docket and therefore not subject to explaining its reasoning? So I'm not an expert on the shadow docket, but I believe that this would qualify as what's often referred to colloquially, right? It's not a term of art. It's not something that we have like a particular definition for, but an unsigned sort of reasonless decision issued by the Supreme Court. These are largely understood to be handling procedural matters, and arguably that's what this was. I believe it would be part of the shadow document. Is that correct, Anaya? Right, yeah.
I was wondering here in this particular case, since Republicans are known for, talking and touting the economy so much, doesn't immigration in itself play a significant role in this country to economic benefits?
Yes. Yes, absolutely, right? Here in the state of Florida, right, the two primary sort of industries that are affected by non-citizen labor. And let's keep in mind that when we're talking about non-citizen labor, we're including a whole panoply of people in different immigration statuses. This presentation was primarily focused on undocumented immigrants, which is certainly a part of that, but it's not the whole story, right? Anyone here on any type of temporary visa, of which we have a whole alphabet soup of different temporary visas, anyone who's here as an LPR with a green card, right? These are also non-citizens that make up part of our labor force and make up a lot of it. Here in the state of Florida, right, two of our largest industries, construction, hospitality, right? Both heavily reliant, and then agriculture, heavily reliant on non-citizen labor of various kinds. So is there an effect? Absolutely, right? Is that a price that the legislature of Tallahassee is willing to pay? Seems like it is.
It used to be that people who wanted to enter the U.S. illegally snuck in with special people who specialized in smuggling you. Now it seems people go up to the nearest ICE officer, tap him on the shoulder and say, "I'm here for asylum." And many people are here that way because it takes years and years before their cases will finally come up. So it was suggested perhaps that when someone is seeking, fleeing persecution, instead of coming to the United States, they should go to the nearest place that's safe, which might be the next country or two countries away. And there is where they have to seek the asylum. So this seems to be a workable solution to the mass of immigrants that are flooding our country. Any sign that that might actually happen?
Well, let's unpack that because there's actually a lot there, right? First off, you're absolutely right. Oh, you're absolutely right that as far as immigration demographics, and when we're talking once again about undocumented populations, we have seen a shift in about the last decade where previously the primary driver of undocumented populations was actually illegal border crossings, right? About 10 years ago, we started to notice that the numbers seem to flip, and now the majority of the undocumented population are visa overstays, right? So people who come in on a temporary visa and then overstay the visa, right? And I believe the numbers have continued to grow, and that as a percentage of the undocumented population for those visa overstays. Part of that is that we're making border crossings so much more difficult. Beginning in the 1990s, actually under President Bill Clinton, we started this enforcement strategy around our border where we tried to basically focus our border enforcement resources around major urban centers and the main crossings, right? Which forced anyone who's trying to cross the border illegally into increasingly inhospitable territory, right? The deserts, the mountains, the things that would be very hard to traverse, right? We were basically relying on that inhospitable terrain to try to dissuade people from entering. And of course, we've continued to build out our border enforcement apparatus, right? We've built it into some of this, but there is still a population that's entering the United States by illegally crossing, right? With the use of what is often referred to as coyotes, right? The population that shepherds these individuals into the United States. I believe you were pointing out that if you present yourself to a border patrol officer and you indicate that you have a fear of return, right? We, the United States, are a signatory to various international treaties that require us to protect individuals and not send them back to countries where they fear persecution, torture, any other host of atrocities that might be used against them, right? And so we do have these international and domestic obligations to basically bring them in and actually test, do you have this fear that you allege to have, right? We have an entire apparatus sort of structured, and that has been in place since, I believe, the 1980s, right? So that's not new. What is new is that basically, especially under the Biden administration, we were creating a more robust system for allowing people to present themselves and make these claims. On the back end, we still had the same system for testing those claims, but we were just sort of structuring and giving order to the people who are presenting at the border. Think the CBP-1 app, if you remember that from a few years ago, right? That was sort of the line, if you will, for at least trying to present and do that. Has there been abuse of the system? Absolutely, right? But we do have these sort of international and domestic obligations to at least test what people are saying. Now, what you're describing is a safe third country provision, which we actually do have built into our statutes already. The problem is, especially when we're talking about migrants coming across South America, is that it's sometimes very difficult to find a safe third country along the way, right? And we saw this happen quite a bit during the debate over Title 42, right? When initially Trump and Biden continued this policy, he was no saint on immigration either, of basically creating camps on the Mexican side of the border while people tried to litigate their immigration cases and their asylum claims, right? What we saw is that this population was heavily vulnerable, even in a country like Mexico, which for Latin America is relatively stable, relatively robust sort of government protections, again, relatively. But these populations were being harassed and intimidated, sometimes kidnapped and assaulted by various non-state actors, even when they were on the other side of the border. So practically speaking, maybe that would be a solution if we had sort of reliable partners in that. And I don't know that we do, maybe, but I don't know that we currently do.
This is sort of a follow-on to Maurice's question. Specifically, I understand that ICE is picking up people who have come in by air, immediately asked for political asylum, went through all the paperwork properly. I have a particular case my church has adopted. They were going back and forth to Jacksonville, and they were following all the rules. They were picked up by ICE on the grounds that they hadn't completed some papers that they supposedly had gotten. They hadn't gotten the papers. They had just been to Jacksonville 4 days before. They were picked up with a 4-year-old child, taken to Jacksonville. The next day, transported to Dilley, Texas, to a prison there. That's where they are. Then they were told by ICE that they were subject to deportation to Iran, where they had become Christians, so they were going. It was like a death sentence if they went back. They were told that in 2 weeks they would be deported on the grounds that they had not properly filled out the asylum papers, because you have to be arrested before you are given asylum, or before you even can request asylum. So that's where it stands now. So my question, I guess, is, I better not swear. No, my question is, what is the definition of an unauthorized immigrant, and would somebody in this situation be considered unauthorized?
That's actually an excellent question, and one to which I don't have an answer, because we don't have a definition for what it means to be unauthorized. And if you notice, that was a term that kept coming up in a lot of these various provisions of state statutes, saying unauthorized alien. The use of unauthorized as a modifier is all over these statutes that we talked about, and it's often not defined. The Florida legislature has not defined it, right? And the nearest corollary is something like undocumented, which is sort of more regularly used, but even that is not a term of art, right? We don't have any provision of our statute defining undocumented individuals. The best we can say is people who are out of status. Seems simple enough, but if we dig a little bit deeper, we see it's actually pretty complicated and has been subject to sort of a lot of political manipulation in the recent years. If we remember back during the presidential debate, where I believe now President Donald Trump famously said, they're eating the dogs, they're eating the cats, right? As part of that narrative shift, what we saw was that they started claiming that these Haitian immigrants who were here on TPS were undocumented, right? And the reason that they were partially able to get away with that is that TPS, it's a type of status, right? But it's a very nebulous, almost liminal status, right? It's done when we as a country designate a specific country for a temporary period. The T stands for temporary, to allow them to stay in the United States. We don't create any pathways to citizenship. We don't create any pathways to other forms of immigration status. We just say, for the time being, we're gonna allow you to stay here on TPS, and here's a work authorization, right? Is that status, right? Maybe that individual is undocumented. I would say generally most of the population would probably agree that's a documented type of status. But here we saw that, as part of this debate over that, right? Like they were shifting the goalposts and saying, no, that's undocumented even, right? We see people who are admitted into parole, which is not a form of, but it does allow people to physically enter the United States, remain for a specific period of time, and also get work authorization, another type of liminal status. Is that undocumented? Is that documented? If you file for asylum, like your friends, right? You're not given any formal status while that's pending. And asylum applications can take years to process. We are currently seeing that like our immigration courts are scheduling things for 2-3 years out here in the state of Florida. USCIS, which processes some of these applications, it's a black box. They don't give you a good insight into how long it will take for them to review asylum claims, but I'm also seeing anecdotally years to adjudicate, right? And in the meantime, what are you? Are you undocumented? Are you unauthorized? I don't have a good answer to that because these are just sort of nebulous terms that are often thrown around willy-nilly. And as a lawyer, I do think like I have to point out what does this term even mean, to your point? Yes, okay. The question is, birthrights, should I go, is the state, oh yeah. So is the state versus federal control of immigration roughly equivalent to pre-Civil War arguments regarding abolition versus slavery? An interesting question. I guess the difference is that at least pre-Civil War, right, we had specific states that allowed slavery and states that didn't. It was a pretty clear demarcation. Whereas here we see states challenging the paradigm, but they're not in positions to necessarily be, or at least as these matters are being litigated, positions to actually create separate carve-outs. So while I can definitely see some parallels, I don't know that it's a perfect analog to the pre-Civil War slavery question. And should I do question 3 before? Yeah, okay. So the third question is, birthright citizenship is written into the 14th Amendment in clear language. Any idiot can read. How can the Supreme Court, dominated by conservative Republicans, question this when they came from the philosophical background criticizing so-called activist judges who they argued didn't pay attention to the precise language of the law and read into it ideas that were not there? So I just want to clarify that the Supreme Court hasn't ruled on the birthright citizenship question, right? While they took up the case with a very narrow question in mind, specifically the question of the nationwide injunctions. They didn't touch the substantive questions in the case, right? And that was largely because of the federal government's design and strategy in litigating. When they were finally seeking certiorari, which is when you request that the Supreme Court hear your claim, they were saying, all we want you to consider is this nationwide injunction question. We don't want you to consider the birthright citizenship question that gave rise to all of this, right? I believe it was Justice Sotomayor who rightfully, I think, calls out the government for their gamemanship, where they were very clearly trying to be strategic in how they presented this question to the Supreme Court because they knew, or they suspected, I would say, that they had the votes on the nationwide injunction question, even while probably recognizing that I would think, or I would hope, that they don't have the votes on the birthright citizenship question that's at the heart of the issue, right? But, I don't know that the Supreme Court is always the most diligent in these questions, in these matters.
Yes. 2 questions, one simple. The injunction on SB4, before it went to the Supreme Court, the state and some counties disregarded it and said they didn't feel the court had jurisdiction. Now that's gone to the Supreme Court and they've sustained the injunction, I haven't heard anything in the news about it. Can you tell us what's happening?
So the last I heard, and I haven't been following this super closely, unfortunately, but was that I believe district court, I want to say, was considering holding Uthmeyer in contempt for his statements. I don't actually know that they issued any sort of contempt finding or order yet. But they were definitely presenting that argument that by the statements that you made, by basically ordering people essentially disregard the injunction that was in place lawfully so, right? Your remedy isn't to go to the public and say, ignore this order. Your remedy is to appeal through a court process, which they were doing. But last I saw was that they were considering contempt charges. I don't know what came of that though.
Well, my question really was, aside from that aspect, now that Supreme Court has upheld it, is the state complying?
Okay. It's like, are people actually enforcing the stay or not? I unfortunately, I don't know. I don't have any insight into whether or not the state has continued to try to enforce it. I haven't seen any reporting to suggest that they are, but I don't know how much value to place on that lack of information.
We're trying to move questions around here.
Thank you for your presentation, and I'm very interested in the questions. I'm with a group here in Gainesville, an interfaith group that has been visiting the detention center at Baker for the last 10 years. I haven't been with them that long, but long enough to know that at the last time that I was up there, the people that we talked with, most of them were not criminals. You can tell right away because they wear a different color jumpsuit. And the question that I have really is, the guards themselves vary between passive and cruelty. And my concern is the acts that are going on up there, and not just there, in other detention centers, are beyond anybody's comprehension. And what I'm really worried about is that they are restricting access to them. Initially, it was really just locating them very far from family, from lawyers, but now it's even worse. For example, we've been trying to get what they call a stockholder visit, and usually we can go up and in that case actually see the people as opposed to seeing them on a TV tube. So my question is, is anyone addressing that? And my second question is, we need to come to the reality that with sea level rise and climate change, we're going to see a lot more people moving between countries. And we seem to be very ill-equipped to handle it.
So I'm going to try to take the questions in the order that they were presented. So you were asking about Baker Detention Center, but the issues that you were identifying aren't limited to Baker, right? As far as poor quality food, healthcare, access to services, conditions. In my experience, this is anecdotal, I've seen that that's pretty common in our detention centers. Now, just by way of primer, when we're talking about immigration detention centers, this is intended to be a civil form of confinement, not punitive in nature, but civil, right? Specifically, the idea is we're going to prevent this person from disappearing, from being a flight risk while we adjudicate their case. Unfortunately, in reality, what we see is that the conditions that these individuals face is identical in every way, shape, or form to that we, for individuals that we place in criminal confinement, right? A big number of our detention centers are basically contracted with various sheriff's department, as is the case in Baker, right? That's the Baker County Sheriff's Office, their detention center. They specifically contract with ICE and DHS to allocate a set number of beds for the purpose of detaining these individuals, right? The conditions are identical in every way, shape, or form as the conditions in which they detain the criminal population or the population that they are charging with criminal offenses, right? So right there, that's a big sort of difference between our legal fiction and the reality of how we're detaining people. are people doing anything about it, right? The ACLU of Florida has brought litigation against Baker County Detention over a number of these different conditions at the detention center, arguing that improper food, proper access to health care, I believe inadequate access to legal counsel, right? A lot of these are being litigated, but it's effectively a game of whack-a-mole, right? Where every case is a big lift that will take years and a number of resources to bring, right? I believe the ACLU of Florida has been at this for 3 years, more or less. Still going on. I don't know if there's an end in sight, right? It's going to be a while of them litigating this. So people are litigating it. It's just that litigation as a tool has its limitations. And I think that's maybe what we're identifying. I'm sorry, I forgot your second question. Oh, yes. Increased displacement. Increased global displacement as a result of climate change. Is that correct? I mean, absolutely. Our immigration system, I think to your point earlier, it's crumbling. It's not up to the tasks of the modern era. The last time we did a holistic sort of reformation of our immigration laws was the 1960s, right? I believe it was 1964 was the last time we did sort of a floor to ceiling redo of our immigration laws. We've tweaked stuff around the edges. We've changed things, but that's the immigration laws that we have, we've inherited. You know, are we due for comprehensive immigration reform? I would say absolutely. Do I expect that that's going to happen in the foreseeable future? Unfortunately, no.
I was hoping we could return to the issue of temporary protection status. Prior to January 20th, 2025, people from certain countries automatically qualified. Venezuela, Haiti, Iran, especially non-Muslim people in Iran, were granted TPS automatically. And the people in Afghanistan who had actually done exactly what they were supposed to do, filled out everything. These were people that aided our forces in that country and were left behind. Those cases were in process, and as of January 20th, 2025, temporary protection status was revoked. I believe for all of the countries, is that correct? And well, aside from the fact that it's awful, could you clarify something of temporary protection status?
Absolutely. So I don't, off the top of my head, know all of the countries that are designated for temporary protected status. I do believe that while the Trump administration has certainly been removing a number of countries, I believe all of the countries that you've identified that were previously designated for TPS, he has removed those from TPS. But there are other countries that have previously been designated and I believe are still designated for now to receive TPS. Now, TPS is often conflated with asylum. There are similar provisions and disqualifications to both. And often, if you're in a position to be coming from a TPS country, a designated country, you might have an asylum claim. So they tend to be conflated. But I want to pull them apart to answer your question, because I heard you mention about like people from Iran who were Christian, right? Well, or Baha'i, or any sort of religious minority, right? That's that's usually what we're articulating with that is an asylum claim, where they fear persecution if they return to that country on account of X or Y protected class, in this case, religion, right? TPS is something where the federal government has to designate a country for receiving temporary protected status, TPS, in the United States. It doesn't necessarily have to do, or it's not limited to circumstances where a population is being persecuted by the government. It can be because of natural disaster or some other thing, but it does require that federal government designation, right? And unfortunately, the way we structure TPS is it gives a huge amount of authority to the president to make those designations, right? So as you mentioned, when President Trump came into office in late January, he started signaling that he was reversing these decisions. Those decisions have been subject to like significant litigation, some of which has gone up to the Supreme Court as well. But at the end of the day, they do have a wide authority to ultimately rescind that designation of TPS. And our current laws don't have much recourse that they afford to those affected populations, unfortunately.
Used to be the path to citizenship was pretty easy. About a century ago, you've lived here for 5 years, and you go to the nearest courthouse, and an hour later, you were a citizen, naturalized. Could you tell us about the law that was passed in around 1925 or 26 that changed everything?
So it's actually pretty interesting because I'm actually in the works of developing a citizenship class where we discuss the idea of citizenship, because while in some ways our laws did allow for a little bit more of an easier way to acquire it, they were up until I believe the mid 20th century, if not maybe the 1920s. I don't know a specific statute you're referencing, but also racially coded, right? Where we didn't allow non-white populations to acquire citizenship, even if we had other sort of reduced requirements that traveled with it. And out of that, in the late 19th century, early 20th century, we actually saw a lot of litigation over what is whiteness, right? We see people who claim to be of Aryan descent from countries like Syria saying, well, I'm white, right? I'm not black. And that seems to be the paradigm here. And the courts, and actually made its way up to the Supreme Court on a number of occasions, had to sit down and say, well, are we adopting a scientific definition of whiteness where we conflate whiteness with Aryan? Are we using some other sort of culturally informed idea of whiteness? And so it's actually been heavily litigated. I think to your point about sort of what are the specific formal requirements, right? That 5 years, yes, it's 5 years, generally speaking, currently, but it's 5 years as a green card holder within the United States. Remember, we've been talking a lot about undocumented populations, but that's a small subset of the non-citizen population. In order to become a citizen in any status, regardless of where you start, you first need to pass through LPR, lawful permanent residency, before you can apply for citizenship. In the vast majority of those cases, currently, you need to wait 5 years. There are certain subcategories where you can wait 3 and then apply, right? But generally speaking, you have to wait those 5 years as a green card holder. A number of our different immigration statuses don't give people direct routes to get to that green card position such that they can serve the amount of time and then become citizens, right? So that is usually the primary sort of stumbling block for individuals. I would say that currently we also have a civics test, English examination, right? For a vast majority of people. In some cases, those are waivable. But generally, those are sort of the general roadblocks to acquiring citizenship. Going to that 1920s law, again, I don't know the specific statute. No, I heard you. So the Johnson-Reed Act, but I don't know specific provisions around naturalization that were in that act off the top of my head, unfortunately. So I don't know that I can comment on it beyond that. Sorry.
I have a comment and then a question, maybe. It seems the latest, there was a poll done, I don't remember who did it. And I think it has to do with the concept of people moving because of climate change and other reasons. I think there was a poll said that there's a minimum of at least 200 million people who would like to immigrate to the United States. I mean, that's a huge amount. I don't know that we could absorb that amount. It's probably even greater than that with some of these countries having various kind of problems that may get worse, and there are going to be more and more people who want to come here. And I think that's why we really need to change our immigration laws one way or another, okay? And I don't know which way, but we've got to do something about it, because can we absorb 200 million people in this country? And I don't think so. I don't know if anybody here thinks so, but it could even be greater than that. And my other question is, I'm thinking that how many other countries have imported gangs into their country? In other words, we have Haitian gangs, we have Mexican gangs, we have MS-13, we have Trinidad de Agua, we have, now it's true in the past, we had Irish gangs, and we had mafia and all that, and that's not good. But it seems like it's getting worse because of the open borders that we've had and the problems that we have. And I'd like your thought on how do we prevent some of the devastation that's happening to our country via these gangs, the bringing in of the drugs, the creating this massacre of our children brutally. I mean, 80, 90,000 children last year died from fentanyl that's being brought in by these gangs. So what do we do about it? And I think the other thing is our states are trying to do something about it, where the federal government has failed. They failed for, as you say, for 40, 50 years. They have failed. Our Congress can't get together on an immigration bill. So the states are trying to, at least some states are trying to protect their citizens against this onslaught of these gangs and what the gangs bring with them.
So I guess taking your two questions in turn, right? To begin with, about the sort of 200 million figure, I don't know where that's coming from. I can't really comment on it. And I don't know as far as like the polling, right? If anyone remembers 538, right, which was a subset of ABC started by Nate Silver, a lot of their commentary focused on what makes good polling, what makes bad polling, and what is everything in between. Well, I think the number is pretty important though, right? Especially if we're trying to figure out as if what our population could and couldn't absorb, we do need to nail down the number, right? But I think we'd have to really take a close look at the study that you're citing, right? I don't have it handy, right? So, right. But as far as what our population can absorb, I don't have specific figures, but I am going to pose a few questions, right, for you, and in turn. Our labor force is, for better and for worse, heavily reliant on undocumented and immigrant labor. Remember, let's not limit immigrant labor to just undocumented populations, right? We're also talking about highly educated visa holders. We're also talking about family members. We're also talking about religious workers in a number of occasions who come to the United States for a variety of different reasons to work, contribute, whatever it may be to the United States, right? Are we at market equilibrium on sort of allowing people in? I would suspect no, right? Because our numbers when it comes to visas have been frozen in time for decades. To your point about how Congress has failed to act on this, right? We are effectively working with the visa numbers from, I believe, like the 1990s in the vast majority of these categories, right? Which are just holistically unsupported for our current modern economy, right? So if we are talking from a policy perspective of what we need to do, I think we do need to take a fundamental reevaluation of like, what are our priorities? What are our values, both from an economic system, but also from a civic system, from a civic perspective, from a cultural perspective. Who is it that we want to be? And then start there when we're evaluating these various categories, right? I don't know that I would necessarily say I'm pro open borders, right? Which seems to be sort of what you're responding against. But I think that there are certainly people out there who make, I think, relatively compelling arguments for open borders as well, right? I'm not an expert on that, so I don't know that I can really defend that position. But that's out there, right? And I would think other people would maybe be better suited to engage on that point. Your second question had to do with gangs. Oh, and sorry, I started laughing because one of the interesting features about that is that we actually created a number of these international gangs and then we exported them, right? If we're looking back to 1980s and 1990s, as part of our Cold War policy, we were actually allowing certain populations of Central Americans, specifically Central Americans in particular, in the United States, we were allowing them to ethnic enclaves where they were often victimized by American-born and bred gangs, and they responded by organizing themselves into their own gangs, right? Most famously, MS-13, right? Which then we came in after they had sort of started organizing themselves into gangs under the American tutelage, and then we deported them back to their central countries that were deeply unstable because of civil war, because of our Cold War policy where we interceded in these governments, and we sort of let them propagate, right? Until they then came back and started also presenting their own set of problems for us here in the United States. That's a challenge. However, and here's where it also gets thorny, is what we're talking about when we're talking about gangs is often, one, we have to sort of come to an agreement on who are we talking about, what are the numbers, right? What is actually happening? And I don't know that our political discourse is really engaging in that heavy lifting of sort of, let's at least come to an agreement on the basic facts, right? About these gangs and what's going on. And then we have to actually say, what aspect of this is immigration? Right? Because so much of it is often conflated. If we're talking about mixed status families, if we're talking about people born here, 14th Amendment applies, right? Then suddenly it's less of an immigration question, just a domestic, born and bred, gang question that we have to issue, and we can't export that problem away through our deportation apparatus. So I agree, it's a very complicated question. There's no easy solution to what do we do to the gangs, but I also think we have to spend some time just like sort of coming to shared agreement on like, what's the terminology? What's the data say before we can really engage in meaningful policy discussions about it, unfortunately. And I don't know that that's happening.
You've really given us a lot of food for thought and controversy and all that. I think we all agree that the system needs to be changed, preferably through some kind of coherent change in the whole system. I was always under the impression that economic hardship was not a justified reason for getting asylum. Maybe it motivates people to move into the border areas, but they shouldn't be given asylum if they're just fleeing economic hardship. That's why my former employer, USAID, was trying to improve situations in Central America. But that's just one. I don't know if, is climate change a legitimate way to justification for coming into this country? Because we have our own climate change. So do you know are there criteria spelled out?
No. We don't have any sort of provisions that allow for either economic migration, which it seems to be you're describing, or sort of environmentally displaced migration. What I would say is that people are calling maybe for a reconsideration of whether or not we should develop those mechanisms, right? I think primarily a lot of the question under which this is often couched is, should our asylum and refugee laws recognize people who are displaced because of climate change, who are displaced because of economics? Because currently they're not, right? We only recognize refugee and persecution if you face, refugee and asylum if you face persecution on account of one of 5 protected classes. Persecution is something that needs to come from either a state actor or a non-state actor that is basically allowed free reign by the government in power in that country, right? As you can tell from that definition, there's nothing in there that would allow someone who's saying, I just want a better job to come to the United States. There's nothing in there for someone who says, my farm isn't producing, I've got no other means to feed myself, let me go to the United States, right? Neither of those are covered. And as far as the discussions I've seen around that, a lot of it is often sort of couching in, should our asylum laws recognize this as something? Not, I mean, obviously there's other ways of addressing this, but that's largely what I've been seeing. I wouldn't expect there to be meaningful change in the near term on that. It doesn't seem to be going anywhere, but that is a topic for conversations, at least among scholars that I've seen.
We're almost out of time, so I want to thank everybody, but I want to finish with the last question, even though there's one on the screen, but I'll let you answer that one afterwards. I was having a conversation with my son about this in the car, and he said, well, what about due process? How can they be snatching people? How can ICE be snatching people off the street and sending them to Alligator, Alcatraz, or anywhere else? Isn't there this thing called due process? And I said, well, you know, as a constitutional law professor, I can tell you that due process has a lot of different meanings and it's very ambiguous. So could you just very briefly give us some sense that my sense is that the due process protections that you get if you're a citizen versus a green card holder versus a whatever visa holder versus seem to be different. And where is that coming from?
Right, excellent question, because yes, due process does mean different things to different people in different circumstances, right? And when it comes to immigration, again, we're talking about primarily civil enforcement apparatus, which also sort of often carries with it a reduced level of due process that's afforded to the individual if we're comparing it to the criminal justice system, where we have more robust due process protections are afforded to individuals. So right off the bat, whenever we're talking about immigration, it's a different world than what we often imagine as far as the criminal justice due process understanding. What further complicates it is that we also recognize that the federal government has often plenary power. Plenary power means basically unconstrained by the Constitution authority when it comes to determining who we allow into the country. And what we've seen in recent decades is that we've sort of done some legal jujitsu in defining what's entry into the country mean, right? If you're presenting yourself for admission and you haven't been here for two years or more, you're not really here. We've created this legal fiction where you're sort of treated as if you're at the border. And because of that, we have things such as expedited removal, which is definitely a reduced form of due process. I would argue even an abdication of due process, if that, by which basically you are allowed to be detained, you're allowed to be deported, unless you can make out some claim that you have a credible fear of returning to your country. Who hears that claim as an initial matter is a CBP officer, right, or DHS officer, not an immigration judge, who is a type of administrative law judge. Actually, I don't even want to use the term administrative law judge because technically they are not ALJs, but a type of administrative law judge, but rather the police officer who's in charge of that deportation, right? So in that expedited removal circumstance, you're not even really talking about something that I think is intelligibly due process, but that's a system that we have carved out and unfortunately is codified into our statute. And our Supreme Court has often recognized as part of that sort of panoply of plenary power that belongs to Congress and the president, right? If we're talking about people who have been here on a visa, who have been here for more than 2 years, even if it's out of status, right? Then suddenly that legal fiction isn't applicable, right? Suddenly those people are people who are afforded a different type of due process by which they're allowed to present their claim in front of an immigration judge. An immigration judge is an employee of the Department of Justice, right? As an employee, they do not have life tenure, they have a limited amount of autonomy, and they are reporting to a boss who is the Attorney General, right? And because of that, it's sort of an open question of like how much, how independent is their judgment, right? Is this really sort of an impartial judge who's ruling? Yes, there are sort of, there's a corporate veil, if you will, between them and the trial attorney who's appearing in front of them, who's a DHS attorney, but they're both government employees of the executive at the end of the day, and they both report to somebody at the end of the day, which is sort of an executive official. In those cases, those judges do have these sort of dueling duties of trying to be impartial as best they can within that system, while also having the duty of developing the record, of doing all of the other things that anyone in an administrative process would have to do to make sure that subsequent reviewing bodies can review it, right? And that's sort of where we have some of these due process, right? But that due process looks very different. We were having a conversation about how due process in the immigration context looks very different. Rules of evidence do not apply when we're talking about immigration courts. Total disclosure, I don't know my rules of evidence. I never have to use them. When I go to immigration court, the standard is relevancy. That's it, right? I don't have to worry about hearsay, whatever say, right? Like it's all admissible as long as it's relevant. And that's what's like the standard is. That has pluses and minuses as far as like, is that due process we would recognize in a traditional court system, right? Criminal justice? Absolutely not. But it's the due process that we've allowed to sort of propagate in this specific context.
All right, well, thank you. We are over time, but I'm sure Juan would stay here and talk with anybody personally. I really appreciate it. Let's give him a big hand for enlightening us.